to start off, unfortunately, with a tragic situation with the North Carolina Supreme Court. They're opening up a pathway now for a mother to take a state trooper to trial. Lisa Higgins, if you remember this back in 2022, the mother of Michael Higgins, who died in a car crash that was driven by Omar Romero Mendoza. The court records show that Higgins was in the front seat of a patrol car when Mendoza only had one hand on the wheel of that patrol car, lost control, going 113 miles an hour in Pitt County. Now, Higgins' lawsuit alleges that Romero had his supervisors ignored policies here and that if followed, that would have kept her son alive. Talk a little bit about this case and how it is able to go forward now.
That's a great question, Brian. A lot of these cases don't go forward. Like you mentioned, unfortunately, this individual was killed in a car accident in 2020. Family brings the lawsuit 2 years later, 2022, in Pitt County, North Carolina, and it takes it to Superior Court. Superior Court judge, you got, like any complaint, you'll have a person file a complaint, and you'll have the other side respond. The other side responds and asks for a motion to dismiss for summary disposition. The court grants it based on a failure to state a claim where relief can be sought. Most of the time, those complaints, specifically against law enforcement officers, will be connected to some type of immunity, either qualified immunity or some type of protected immunity because there's a state entity. The family was not happy with that outcome, brought a lawsuit and continued their appeal to the Supreme Court. To the Court of Appeals. Judge Arrowood, who's from Mecklenburg County, said, look, this case is not up for a judge to determine. The determination should be made by a jury, specifically to the main question. It's the question at point. Should this be determined, were his actions needless or manifest a reckless indifference to the right of Mr. Higgins? That's what the court said, and that's extremely important when you're looking at these types of cases. Is it up to a judge to decide, hey, this question of material fact should only be answered by me, or should it be answered by a jury of your peers? If there's a question of material fact, if there is a question that a trier of fact jury should be listening for, it shouldn't be up for a judge to make a determination, and it should go to the jury. That's what Judge Arrowood decided.
Very tragic situation, unfortunately, here.
Absolutely.
But there was a long list of things that would signify that it would be you could go to trial for this. Kind of unpack what happens next here, because it is going to go to trial. And also, what does they need to prove to here to be successful?
You're in Pitt County, so this is going to go back to Pitt County. I mean, that you have to take it to trial court. I mean, outside of a appeal process, which has already been done, we got to get to trial court. So first, they need to be able to prove a couple of things. First, it will be rooted in wrongful death. That's tort. That's duty, breach, causation, and damages. It's the ABCDs of tort. Is there a duty? Did I breach that duty? Was I the proximate cause of your death? And then were there some damages that were created or implemented because of my action? So the family will be able to go to that, and they'll point to a couple of things. First of all, talking about the troopers' failure to follow proper protocol and procedure. They'll talk about you violating the highway patrol policies, right? You failed to notify your supervisors. If I can show during trial that, hey, we have these policies in place to avoid these situations. Why? Because we recognize that they're foreseeable. And now you, trooper, have failed to do the things that we knew were foreseeable. Now we can hold you accountable for that. So we're connecting your failure to follow rules that we recognize will prevent death, prevent injury. And now, wait, you actually had a death. Was it avoidable? Was it foreseeable? And keyword, was it reckless? Was it irresponsible? Where there's an indifference to human life? Was it gross negligence? That's going to be the standard.
Why did this take so long to get here where we are now?
The wheels of justice turn slow, Brian. If you're talking about trying to get a case to court, it's already slow. Before appeal, before a case is dismissed, super slow. So now you're telling me this case has been dismissed, and now you have to get an appeal in front of the Court of Appeals, super long. Don't forget, there was also an offer in between there. So files complaint, case is dismissed, case gets appealed, state comes back and says, trooper, I should say, comes back and makes offer to family for $1 million, right? Family rejects that and says, no, we want to go to trial. Why do they reject that? Because you typically don't want to get an offer that pays you, but then there's no admission of wrongdoing. The family is saying, we want you to admit that you did something wrong, and you get an opportunity for discovery. In discovery, I can prove not only that you did this, but you may have done other things that contributed to my son's demise. And so that's why that was something that was off. And also, I mentioned Supreme Court. It sat at the Court of Appeals, but it paused at the Court of Appeals for a minute. They wanted the Supreme Court to intervene. Supreme Court failed to intervene. That's why Judge Arrowwood then wrote this opinion.
You say a lot of cases wind up settling. This case had a chance to settle. It didn't for a large amount of money. Going forward, will this case settle? Will they accept a larger amount? Do you anticipate, or do they really want this to go to trial? And to the other side, they don't want to go to trial.
I never say that settlement's off the table, right? There's always a place, a sweet spot for both parties involved in a negotiation, right? There's an opportunity to find out what that looks like. But sometimes finding out what that looks like is money, but sometimes it's accountability. Sometimes it's responsibility. And if you're saying that you, as in the trooper, is not going to say, yes, I was at fault, I admit wrongdoing, then the other side may say it doesn't matter what the dollar amount is, then we'll never settle. We won't know that because we're not invested in the internal negotiations, but there'll be signs. I mean, during the process of discovery, interrogatories, depositions, all those things, they'll get answers to their questions. And if the plaintiffs are finding out that things they want are pointing to wrongdoing, there's no need to settle because they know they have them where they want them.
But you have a family here. Obviously, they would want closure. You would think about that, but also attorney bills that are racking up here.
Yeah, I mean, but most law firms are going to take these type of claims on a contingency basis, right? So this is where the law firm now is taking the risk. I take the claim for 33 1/3 or 40% of any potential recovery, and so now law firm is fronting all of the costs. They're paying for this discovery. They're paying for the interrogatories and depositions. They're covering any experts that come in to testify. And so the family isn't eating that cost. It's just something that on the back end is going to now have to come out at a potential if a resolution is in their favor. But on the other side, I talk about the risk. The law firm, if they're unsuccessful at trial, all of that money they spend in preparation is now lost because you're unable to recover anything. So it is definitely a zero-sum game for the law firm.
Queen City News Plus. Just search Queen City News on your smart TV's app store.